Hi everyone. I was going to try and review your comments or questions with respect to answers quickly if I could. Lisa asks, if a complaint's denied, does that mean the case is closed? I'm a little nervous about the word denied. You can see that we have a lot of language that kind of one runs into the other. So if you file denials for the complaint, that doesn't mean the case is closed. If the complaint is dismissed, then the case would be closed. But denying aspects of the complaint in your answer doesn't mean that it's closed. It just means that you've responded in the pleadings. I asked Atia to be a little more specific. I haven't heard back from her, so I'm not quite sure exactly what it is that she wants me to address. Carla, a number of people asked about why do we do this business with no general denials in the Pennsylvania courts. It's really, I think, a product of the fact pleading versus notice pleading. Fact pleading is supposed to be more specific to give you all of the detail in the case early on. Notice pleading is designed to give some notice but not all the facts, with the idea that during discovery, the process of finding out information about the case, you can do all that then. So that's why I believe it is, as opposed to any other reason. Rick asks a question about if you want to file an answer, do you have to be detailed in the answer and then come up with your new matter in state court or affirmative defenses in federal court? The answer has to be in the proper form or it'll be considered admitted. So you would do an answer, and then as part of the answer you'd have a separate category called new matter, which would lay out your affirmative defenses in Pennsylvania. In federal court you'd have to do your answer, and then you'd have to do your, which in federal court could just say denied, and then under the answer you could have separate defenses or affirmative defenses, and you'd plead them that way. Let's see. Yes, Allegra asks a good question, and this would be an important one to know. What if part of the allegation is true? Then you would answer admitted in part, denied in part. And then you'd tell people, admitted that so-and-so lives at this address, denied that they lived there on that date, they lived at another location, and give the location. So admitted in part, denied in part is called a hybrid answer. And again, same rules apply. You have to explain what you're denying. Again, another couple of questions about why do we do this in Pennsylvania? We just do. And again, it's the fact pleading versus notice pleading. Atia asked, if you resubmit a claim that's been denied, you find something different would help prove your case. Probably not, but it's hard to tell. I can't give you enough information. If you filed your claim and it was dismissed by a demurrer, said you didn't have a legal basis for it, it probably would be tricky to find something else. If you did, you could try and attach it and go forward. It may fall into that area of defenses that we call res judicata. That means that we have decided this case already. If you can show it's different and you have a good basis for it not having been waived by you by your failure to find that other information, you may be able to go ahead. Gabrielle asks a really good question, and I think I've said this before, but I'm going to say it again. The answer and the complaint should be mirrors of each other. Paragraph 1 in the complaint should be responded to in paragraph 1 in the answer. Paragraph 13 of the complaint should be responded to in paragraph 13 of the answer, and that should always be the case. Otherwise, you're going to make a train wreck. Pat asks a really good question too, and she said, could you just answer all the allegations in the complaint this way? This allegation does not relate to defendant, and accordingly no response is required. She's thinking like I do, because I'm always I think she's looking to try and avoid having to do extra work. But let me tell you, more commonly, the response that people will throw in is the following. Denied. After reasonable investigation, the defendant is unable to either admit or deny these allegations, period. That's okay if it's obviously something you don't know. If you, let's say you have a contract in your possession and someone asks you a question about that contract and you say, denied, after reasonable investigation, we're unable to either admit or deny this allegation. It wouldn't be an answer in good faith. That is, you would know the information. As with respect to this, if the allegation really did relate to you and you put this allegation does not relate to me, that's in bad faith, and the other side could ask that your case be dismissed or the preliminary objections granted, and judges will often do that. So you can't get away with a, quote, I'm going to call it a cute answer, if you will. I hope that makes sense. Colleen asks, do other states have requirements of pleadings like this? I believe some do. I don't honestly worry about them because I don't practice law in those, and I really just address what we have. But I'm sure some states have similar requirements that you're specific in your answer. Someone said, well, in federal court, since the claims are higher, they're not always higher. It's just federal court has a limit for some claims. Remember, with diversity of citizenship, you need a $75,000 claim. There are plenty of $75,000 claims in the Court of Common Pleas as well. So it doesn't necessarily mean it. The reason for the federal system is just based on this notice pleading business, not having to do with anything to do with the size of the claims. To my knowledge, Pennsylvania has almost always had this fact pleading rule where you need to give good detail of it. Yes, you can deny a part, and Sandy asked, can you deny part of a paragraph? Yes, you can. Again, it's admitted in part, denied in part. Tell what's admitted, tell what's denied, and you'll never get in trouble. Someone asked, if you don't file your answer in time, is that deemed admitted? Not right away. What has to happen is you're supposed to get a notice, a 10-day notice, indicating that you are to respond, or you'll get a default. If they get a default against you, then you're done. And that's really all I have to say. Thank you, everybody.